So good afternoon, everyone. My name is Jamie LaValle. I'm a Muskeg Lake Cree Nation citizen, and I'm also an assistant professor here at the Usask Law, and I'm a member of the College of Law's Speakers Committee. I would like to welcome you to our 2020 Wunusweh Lecture in Aboriginal Law as part of the college's McKercher Lecture Series. I would like to thank the various individuals and corporations who have donated to the Wunusweh Lecture Fund, including the Honorable Judge Gerald Morin, who is here with us this afternoon. Yeah, okay. Did everybody see that wave? No? Okay. Wave again. There he is. So thank you. I would also like to acknowledge McKercher LLP for being the sponsor of the College of Law's Lecture Series. Do we have anyone from McKercher who wants to wave today? No? Okay. Sorry. Their support allows the college to continue to present a wide range of informative, educational, and entertaining speakers to the law school and the surrounding community, hopefully all three at once. I would now like to introduce Ali Baer, VP Indigenous Relations for the Indigenous Law Students Association, otherwise known as ELSA, to introduce our guest speaker this afternoon.
Apetu washe, tue iohana, achiapi, tatankaskawi, makia peye, wapahaska, oyate tahawahi. Hi, good day. My name is Allison Baer. I'd like to welcome you all here today. First, we'd like to acknowledge that we are situated on Treaty 6 territory, the traditional lands of the Nehiyaw, Anishinaabe, and the Dakota Nakota, and the homeland of the Métis. I would like to introduce the Honorable Justice Leonard Tony Mandamin. I'm very honored to be here today and stand here amongst one of our Indigenous trailblazers. Justice Mandamin was born in 1944, an Anishinaabe member of the Wunusweh unceded Indian Reserve on Manitou Island, Ontario. He was called to the Alberta Bar in 1983 and established the law firm Mandamin and Associates in 1985. Representing First Nations, Aboriginal organizations, and individuals. He appeared as counsel before the Alberta's Queen Bench and the provincial courts, and before the Supreme Court of Canada in R versus Badger. He also appeared in the Saskatchewan Court of Appeal in R versus Wolf and the Indian Claims Commission Cold Lake First Nations, the Primrose Claims. He served as an adjunct professor at the University of Alberta School of Native Studies from 1998 as a faculty coordinator for Aboriginal Justice seminars at the Banff School of Management from 1994 to 1998. He was the director and president of the Canadian Native Friendship Centre in Edmonton, Alberta from 1991 to 1995, and as a commissioner and chairperson of the Edmonton Police Commission from 1992 to 1996. He was appointed as a provincial court judge in the Calgary Criminal Division in Alberta from 1999 to 2007, and during that time he presided in the Tsuut'ina Court, which involved the First Nation Peacekeeper Justice Initiative, and the Siksika Court at Siksika First Nation, which also involved traditional Aboriginal mediation. He was appointed to the Federal Court Justice and a member of the Federal Court Martial Court of Appeal on April 27, 2007, and he retired from the Federal Court in 2019. And we would like to give Justice Mandamin tobacco and cloth for being here today and sharing his knowledge with us. So thank you very much.
Ani, Antonin Daben Najnakas, Wukam Kong Sagani Nunjaba, Nisugan Shabim. Chinenda Manpi Aj and Dot, Niho, Minash Uptozi, Minasha Kinugudner Shnabek. Greetings. My name is Tony Mandamin. I'm from Wukwamkong Unceded Indian Reserve. I'm Anishinaabe. And I'm pleased to be here in the land that's been acknowledged by the speaker before me. I want to thank Judge Morin and the Faculty of Law here at the University of Saskatoon for inviting me to give a speech, and I can hardly wait to see what I'm going to say. My topic is a question of justice, but let me just go back in terms of a little bit of a background. As I said, I'm Anishinaabe, and my name is Mandamin. In our language, Mandamin is translates as a marvelous seed or a marvelous berry, and that's our word for corn. It's a family name, and growing up on the reserve, I didn't take too much note of it, but as I went along, it became more and more apparent to me that my growing up in Uquamicoong had a tremendous amount to do with where I traveled. I once asked my aunt why there were Mandamins in Shoal Lake in northwestern Ontario, whereas we were located in Manitoba Island, more in further to the south. And she explained that sometimes they refer to Mandamin as a wandering seed. This, I don't know if she was referring to some of my ancestors or the fact that corn is spread to many communities in Canada. But with this, I ended up, I guess, on this track because of an event that happened in Uquamicoong. There was very little teaching of the culture in the open. The church, the Indian agent, had very much to say about how things went community-wise. And there were a group of ladies on the reserve that were talking, and they decided that they should do something for the community. And they settled on the idea of holding a cultural celebration. Those days it was known as a powwow. And so they planned it, organized it. I was just starting school off reserve, finishing up high school, and starting off to university. And what they were doing was really fascinating to me. And I hung around the organizers as they talked about what they should do and how they should do it. And nobody knew any singing or drumming or dancing. And what they did is they arranged, one of their members, Tommy Pelche, drove out to Saskatchewan and brought back the pie pot powwow people, old Emil Pie Pot and others for the first powwow. And that in Uquamicoong was the beginning. It became, to this day, the longest running powwow in Eastern Canada. They refer to it now as a cultural celebration. But as I participated in the planning and the organizing, I began to hear from people like Jean Goodwill, like Alni Sobamsawin, like Buffy St. Marie, like Bill Whitney, who were talking about national events. And that essentially set me on my road. My first degree was in electrical engineering. These days I explain that by saying I made a mistake. I thought they said engineering. But by the time I figured out the difference, I was so close to graduating, I figured I might as well finish. So with that, I ended up, after graduating from engineering, going out west. I met my wife, a Dene woman. One of the counselors from the First Nation, her First Nation, explained, when you marry a Dene woman, you become band property. So I seem to be rooted in the West nowadays. with that, I was an activist in organizations. It was mentioned of some of the organizations I was involved in. And then people started going to the Native Law Center. And these were people I knew, Marion Meadmore and others. And they were going into law. And I was grumbling about this to my wife, and she promptly told me in a straightforward Denny fashion, well, if you're going to talk about it, you might as well do it. So 40 years ago, I started law school at the University of Alberta. In those days, it was a black letter law school. It was just straight down the middle. There was no such thing as a Native Studies course or an Indigenous course. And I went through that. When I came out, I thought, well, I should be representing Native people and fighting for their rights, having been an activist and taken part in demonstrations and things like that. But what I found in law was that it didn't work that way. There in this journey, if you will, I think where it first really came home to me was the Native court workers in Stony Plain, which is a community west of Edmonton, had found out I was practicing, and they started referring their clients to me when they filled out the legal aid forms. And I would go to represent them. And those days, just days before Stitchcomb, where the Crown's required to disclose what they have, this was before then. But in the rural communities in Alberta, the practice was more, how would you say, cooperative. And I'd meet with my client and hear what they had to say, and then I'd go see the Crown prosecutor, and the prosecutor would take his file and he'd hand it over to me and say, this is what I've got. And almost invariably, I found in the file a statement by my client admitting to everything the Crown needed to prove their case. And I'd go back to my client and I'd say, well, did they threaten you in any way to make this statement? No. Did they entice you? Did they say they'll let somebody go so that if you admitted to it? No. Did you make it voluntarily? Yes. So I'm left with the only thing to do is assist my client in entering a guilty plea and then speaking the sentence. And I did fairly well on that, in that process. You know, I told the court about the individual, their background, their circumstances, and their prospects for a better life. But it became so discouraging. And I was thinking, well, maybe I should be going and giving talks in the communities about your right to remain silent. You don't have to tell the police everything. You can ask for a lawyer and get legal advice. You can insist on your rights to a trial, make the Crown prove their case. You can even ask for a jury trial. But none of that seemed right. Somehow it didn't seem like it was the kind of thing that I should be doing. And I wondered about this. And it ended up, the Indigenous Bar Association asked a group of lawyers, they asked me to chair a group of lawyers, looking into the criminal code and its impact on Aboriginal people. And we were doing this for the Law Reform Commission. So we began to compare notes, and there were people like Albert Angus and Marion Buller-Bennett and Dennis Callio, others. And when we compared notes, we came to the conclusion that, you know, in the criminal code, what were substantive offenses in the code were offenses in the community. You don't steal from somebody. You don't assault somebody. You don't carry on in a fraudulent manner. Most of the offenses, with few exceptions, were really the same. What was different was the bulk of the criminal code, which talked about criminal procedure. And that's where we found there was a difference. When we looked at it, the Euro-Canadian culture had developed this process. The crown, the king had absolute power. He could invade your home, he could take you prisoner, he could hold you in secret, he could have secret trials, he could dictate to the judges what their sentences would, what the disposition should be. And over the years in the English common law system, defenses were built up for that. If a confession was obtained by torture, the court wouldn't listen to it. If there was a trial, it had to be in the open. You had the right to be tried by a jury of your peers. The prosecution had to prove a case beyond reasonable doubt. But that's not how things worked in the Indigenous community. As we looked back into history, we found that it was a very different process in the Indigenous community. In the Indigenous community, it was a question, if somebody did something, these communities were so tight-knit, they knew each other so well, that it was a pretty open matter, they knew who did it. And persons were expected to admit what they did. This was communities, Indigenous communities were horizontal communities where your ability to persuade people depended on your word. If you lied, you destroyed your own credibility. You destroyed your ability to influence people and to have a say in the decisions that are being made. So you admitted it, but that wasn't the end of the story. Somebody assaulted somebody else, but the reason for the assault was because that person had said something that was so hurtful that it generated that response. And what it became a matter for the community was the question, what do we do about it? How do we make things so that we restore the cooperation, the harmony between the different community matters? I guess I'm... So the objective from the Indigenous community was to restore harmony. So, and to get back to what in our language and my community and among the Anishinaabe people, how to achieve B'madzulwin, how to live well. And to live well, you need to have healthy, secure lives. So we had this dichotomy going on, these two different systems. So if you look at an Oxford dictionary, you'll find that there are definitions of justice. The second one is a system of laws and procedures and courts that operate, that deliver justice. That's the second definition. The first definition is a fair process. And that's for Indigenous people what this is all about. Now, when I said 40 years ago I started school at the University of Alberta in law school. Well, 40 years, pretty much to the day, I went back to school at the University of Alberta. This time at the School of Native Studies. And this is my own, how would you say, journey. What I'm trying to do is to go step back from my practice of law as a lawyer, as a provincial court judge, as a justice, as a justice of the federal court, to step back and look at this whole question about justice in Indigenous country more broadly. There are a number of, the Law Reform Commission of Canada, I just described how our thinking evolved in terms of the report that we did for the Law Reform Commission. The Manitoba Aboriginal Justice Inquiry was one of dozens of justice inquiries that were going on across Canada. And all of them reported essentially the same thing. In around the 1950s, not too many people, Indigenous people, were in the jails. And as time went on, that number increased. By the time that the Manitoba Aboriginal Justice Inquiry wrote its report, level of Indigenous inmates in federal institutions about 13%. And they made a whole series of recommendations. In 1996, the Royal Commission on Aboriginal Peoples looked at all of these justice reports that had been done. They published what was called Bridging the Cultural Divide. And they came up with a conclusion. And it basically said, the criminal justice system has failed Aboriginal peoples, Indian, Inuit, and Métis, as evidenced by their overrepresentation in the criminal justice system. The reasons for this overrepresentation are the prevalence of crime in Indigenous communities and the differing worldview of Aboriginal peoples between Aboriginal peoples and non-Aboriginal peoples on the process of achieving justice. Now, as a judge in provincial court, you are frequently involved in sentencing. And sentencing has a number of principles. And the first one is general deterrence. Tell people don't do that. The second one is self-deterrence. Tell that person not to do that. The third one is rehabilitation or restoration, compensation. Out of all of these reports, they added a couple more, which started to incorporate the Indigenous notion of restorative justice. Now, that in that we have there are a couple of things we should be noting. One of them is that business about deterrence. There's been a number of studies that say it doesn't work. Well, let's take a closer look at that. If general deterrence was to achieve general deterrence, you have a range. You have put somebody on conditions, give them a talking to, make them take treatment, fine them, make them pay money. And the most serious deterrent tool is incarceration. Indigenous people at the time of the Royal Commission report was sitting around 13% in federal penitentiaries Today, that was 1996. Today, it's 29%. It's gone up. And yet, this notion of deterrence, this is the strongest sanction you have, so this will make the communities more peaceful, right? No, it doesn't. Indigenous communities have the highest level of crime in their communities. Disorder, disruption. Deterrence isn't working. The self-deterrence, well, this individual, it'll work for this individual. I remember the director of a treatment center in northern Alberta telling me that when they have somebody who has a drinking problem, a drinking issue, they need at least a month with them before they begin to start to face the problem they have with alcohol abuse. But if they went to prison, they said, we need 2 months. They're more hardened. And self-deterrence, everyone knows, I'm sure, the story of the Indian Posse. It's one of the most violent Indigenous gangs you could have. They made it a condition of membership that you had to go to a federal prison. Deterrence? That was, for the people they were recruiting, incentive. So we have these numbers increasing. We get to the measures that that have been taken, and that is what they call the Gladio provision, section 718(2)(e) of the criminal justice system. And that says that a judge, when sentencing, is to take into account alternatives for incarceration. That's for everybody. And then it reminds them, in particular, pay attention to the circumstances of Aboriginal offenders. So we have Gladio reports being prepared and provided to Indigenous or to the courts. So where is that these days? And before I go further into it, I'm going to step aside, and there's a practice of talking about this issue, and they start talking about how big a problem it is, and how many Indigenous people are in jail, and how many talk about what needs to be done. But one of the things that I'm finding is that, and courts do this all the time, but what I'm finding in my own journey and in trying to learn on this is the wrong way to do it. You begin where the Indigenous people begin. R versus Badger was actually, there were three, Kiwasio, Badger, and Aminiak. All were charged either with hunting without a license or hunting out of season. In the circumstances where they were hunting on private land which was unoccupied. A non-Indigenous hunter with a hunting license in season wouldn't be charged hunting in those circumstances. But a treaty Indian was charged in each of those cases. We take the case all the way to Supreme Court. At trial, I had a practice of doing this. A colleague of mine, Judy Sayers, had taken a case to court, and she had the elders testify about the treaty, and the court dismissed the elders' testimony on the grounds that it was hearsay. They were talking about a time before they were around, and that was hearsay evidence, and so she didn't consider it. So what I started to do was I would call an elder to talk about the treaty and talk about their beliefs. And I'd also call an academic, ethnohistorian, historian, anthropologist, geographer, to testify about the same thing. And I had a trial where I called Richard Price, who was the then director of Native Studies at the School of Native Studies at the University of Alberta, and he talked about the work they did with the spirit of the Alberta treaties. And one of the elders who assisted him in that process was Dan Mcclain, an elder from Sturgeon Lake First Nation, been a chief, counselor, hunter, trapper, and he was one of the elders coordinating the interviews of elders in the province in northern Alberta to do this work. And so Dr. Price was qualified as an expert witness, and then we came to Dan Mcclain, and the Crown promptly got up and objected to his testimony. And the judge said, I accepted Mr. Price, or Dr. Price, as an expert witness based on the work and study that he's done, which in good measure was provided by the elder. And he says, how am I to refuse to accept the testimony of the elder in these circumstances? And he admitted the evidence, and after that, I never had an issue with elder testimony in Alberta anyways. And I had Dan Mcclain testify in this trial on Badger. Let me call it up. The trial took an afternoon on a Friday in High Prairie, Alberta. We had 3 trials, one for each of the accused, and it was agreed that the historian John Foster and the elder Dan Mcclain would testify and their evidence be applied to all 3 trials. We lost the trial. The judge was hostile, quite frankly, to the Indigenous witnesses. He swiveled his chair so that the back was to the witnesses. You don't see that in any transcript. And he had made some comments during the intermission when I wasn't there that Dan Mcclain and John Foster heard, and the elder was fuming. And I and the elder talked about it, and the elder was about to tell the judge what he thought about all this, and I persuaded him that he should tell the judge what he thought about the issue, treaty hunting rights. And he did, forcefully. And in fact, turned the judge. But there's been only 2 favorable decisions at that time, probably, I don't know if it is the case today, but only 2 favorable decisions in Alberta on Indian hunting and fishing rights since the 1930s. So all the precedents were against me. Judge said he was bound, he convicted. I also had, at that time, been taking the cases, and I had my successes in provincial court. I was running about 50-50 on these cases. But I get to the Court of Queen's Bench and nothing. Get to the Court of Appeal, nothing. So I decided, I thought I knew the law. I certainly knew the Indian people, but I needed somebody who knew the judges. And I teamed up with Alan Hunter. I tell people it was a treaty Indian hunting case. I'm a treaty Indian, he's a hunter. That's our legal team. And we went. We lost at Queen's Bench, we lost at Court of Appeal, we got it into the Supreme Court, and the decision at the Supreme Court held that the treaty right to hunt continued to exist. It hadn't been extinguished, consolidated and extinguished by the Natural Resources Transfer Agreement. And I don't know, it's been cited something like 350 times. But after it was all over, incidentally, in that case, there were 20 lawyers in court. 6 of them were Indigenous lawyers. And there they are. After that case, Dan Mcclain and I were speaking a month or two later, and I was trying to explain to him how the Supreme Court had reasoned their way to their decision. And I asked him what he thought the Indian law was that should govern. He thought for a moment, he said one word: respect. There should be respect for the treaty Indian hunter and his rights. There should be respect for the landowner, and starting with that kind of attitude, you can work something out. So, but Elder Mcclain's comments started me on a trail of thinking. There's an artist. Artists have a way of depicting these things. The central piece is a piece he called Indian Law. And I said, explain that to me. And he said, well, see the trees, they're straight, that's honesty. See the rock, that's strong, that's bravery or courage. The grass, it's soft, that's kindness. And the animal represents who shares his body with us for our sustenance, that's sharing. And these are facets of what we call in Anishinaabe country, and certainly Dan Mcclain is Cree, so that would be reflected there as well. And I've heard this among the Algonquins. Used to be called the 7 grandfather teachings, although the last time I was taught, it was taught to me was by grandmothers from Gitagongzibi, an Algonquin First Nation. And they are honesty, bravery, love, respect, humility, truth, and wisdom. These are the principles the grandmothers explained that you guide your life by. These are our laws. And you think about it, the criminal code is do not. Indigenous, the grandfather teachings, the grandmother teachings, do this. It's a different way of looking at things. And so I've started to look at things now from the Anishinaabe perspective. We never had this on the reserve. It wasn't taught. It wasn't allowed. But the more I look at it, the more I find that it's still operating. So now, let's go back to the negative. Remember I said, let's not look at the problem first, let's look at what's right. And we have start with the grandmother teachings. One of those teachings is truth. You have to have clear eyes to see the truth of what's going on. Don't fool yourself. Don't ignore the truth. The sketch with the face with the bars, that was done by a friend of mine, Lloyd Caviosi, at a conference in 1968. It was a conference held by the Indian Eskimo Association, and the speaker was the newly appointed Minister of Indian Affairs, Juan Jacques Chrétien, who later became Minister of Justice and later became the Prime Minister of Canada. And he was talking about all the great things that were going to be done for the Indian people. While he was doing that, Lloyd was doing that drawing. The truth. The second one is a painting by Carl Beam, who's a Anishinaabe artist from Manitoba. And let's put it this way, he portrayed what's going on with the Indigenous people. You see the effects of intergenerational trauma if you want to look for it. So what have people said? Well, George Coppleway was a Mississauga Anishinaabe, a Wesleyan minister, and he published a book on the Ojibwe peoples, and he said, we can judge the character of a community by its buildings. And he said, of late, we see prisons, penitentiaries, and poorhouses. These are bad signs. That's 1850. I've given you the statement by the Royal Commission of Aboriginal People, 1996. Criminal justice system has failed Aboriginal people. Principal reason is the fundamentally different worldviews of Aboriginal and non-Aboriginal people about the process of achieving justice. And the last is a recent paper by Professor Jackson, and he explains it this way. This third model argues that the overrepresentation of Native people in our prisons is a result of a particular and distinctive historical and political process, which has made Native people poor beyond poverty. The process is colonization, whereby we of European descent have come to North America and have sought to make over Native people in our image and take their lands and resources for our economic imperatives. I submit to you that's the truth. So if we continue on this notion, another teaching is humility. Now, why humility? I mean, why you know, you can see bravery, you can see respect, you can see honesty. Why humility? Because humility allows you to listen. Humility allows you to learn. It stops you from saying, I'm always right, to say, I'm ready to listen. I want to learn. As members of the Indigenous Bar Association, we supported the passage of Section 718(2)E. I was part of the IBA delegation before the House of Commons committee during the second reading, so first time that it was introduced in court. And we supported it. But the reason we supported it was that it would leave the door open to allow Indigenous people to have a role in dealing with the disorder in their communities. It would leave the door open for Indigenous restorative justice initiatives. But what happened? Well, the Supreme Court of Canada came out with R versus Gladue and endorsed its use, instructed judges to use it. And then years later, R versus Ipili, the Supreme Court looked at it and said, it's not being used, and it's not being used properly. There is true, look at the circumstances of the individual and assess the degree of moral blameworthiness of the individual, of the accused. But there's also consideration of the measures Indigenous people use to help those individuals get back to a life in harmony with their communities. The title, Ipili and the Duty to Resist, is the title of a paper. It was written in Quebec a couple of years ago, 2017. And it looked at over 300 trial and appellate decisions on 718(2)E cases. The conclusion it came to is there are a few judges who are using it in the way it's meant to be used There are many, many more who ignore it. And there are other judges who say, well, yes, but it doesn't apply in violent cases. That's after R versus Appeal in the Supreme Court. Needs to be a certain amount of humility in us who have been members or have been members in the justice system to recognize we're not doing it right. Tsuut'ina, during this era, decided they wanted to end the conflict in their community. And they took advantage and applied one of those principles, honesty. They said, if an individual admits to what they've done, we will be prepared to hold peacemaking for that individual. They said we'll do it if the person who's harmed participates, because we want to end the conflict, and you can't do it if you leave one out. In the time I was there for 7, 8 years. We had cases that went through peacemaking, other cases just appeared in the court, and other cases that were in other courts in other parts of the province. The lowest rate of recidivism were those who went through peacemaking. And that was just not a fluke for Tsuut'ina. There was Hollow Water dealt with sexual assault in the family, incest. And they had devised this process, a very difficult process of healing circles. In their case, out of some 60 cases, they only had 2 reoffend. And evaluated by a former prosecutor, they had far more success than the criminal justice system had in this area. Another program in Rama also operated. They had 5% recidivism from their process. The Siksika applied another principle, love. They cared for their children. And the elders said, we will help those families in trouble. And it ended up dealing with child protection matters, with family breakup, custody and access issues, and family violence. And they did it because they wanted the children to grow up safe and secure in their homes. We used to get cases on family violence when the ambulance was called. Over time, we ended up with the process. We ended up with the process that we got more reports of family violence. The degree of violence went down, and now was a push down, it was a slap. And the age of the parties went down till we're getting the new family formations. And we didn't get repeats. We got 2 repeats out of some several hundred cases. I would be remiss if I didn't mention the Saskatchewan Cree Court. I've listened to my colleague, Judge Warren, speak about that. But you have to, it illustrates the important principle of respect. Respect the community, respect the culture, and fundamental to all of that is the language. So, 2 other matters now. What do we do about it? Well, for one, it's going to take some bravery. It's going to take some courage. It's going to take some perseverance. The criminal justice system is a massive system that doesn't want to change, even if it says it does. And it's going to have to be challenged. It's going to have to be challenged within the system by judges, by prosecutors, by defense counsel, by police officers. It's going to be challenged by the communities. And that means you're going to have to take on something difficult. And then the second quality is wisdom. And I thought long and hard, do I know of a decision that represented wisdom? And I found it in my own life. When I was a child, I had polio, and I had one leg all pulled up. And I don't know, I was 8 years old or something like that. And the doctors decided that I should be sent to Sudbury, which was 100 miles away, 160 kilometers for the younger people. Mostly over gravel road, rarely visited by people in my community in those days. And they have an operation, and I would be at that hospital for 3 months. And the family was very concerned and frightened about sending me. And there was a family conference about sending me. And it was my grandmother who decided I should go. She was a healer. She treated people in the traditional ways. And she knew what she had could not help me in my condition. And this would be something that would be the better for me, but this was the unknown, because the experience our people had of going to the hospital was you usually died. And so she took, with her knowledge, her uncertainty about what could be done, she made that decision to go ahead and agreed that I should go. Changed my life. I didn't become a great athlete, but I did win the cash money draw on my reserve in a golf tournament one year, about 60 years later. But that's the kind of decision that people are going to have to make. We don't know enough. We can't have all the answers about Indigenous justice. But we need to take that step, because what we're doing now isn't working. So what are the takeaways? First of all, this is not going to change unless Indigenous people are involved. I remember once my father was a soldier in the Second World War. He came back like his other members. They all became alcoholics. I remember one time I had to get him because he was falling down, and he was near the lake, and that could be tragic. And I had to go get him. And you cannot lift up a person who's totally intoxicated. You just can't do it. But if that person is trying, you can. And that's what the Indigenous people are prepared to do. They have their problems, but it's with that assistance that you can start to get at this real problem. The second one is Indigenous restorative justice. It's too narrow. You got to have it before court. You've got to have it after court. You've got to have it after prison. We're now seeing people being released. They're addicted on meth. They end up in penitentiaries. They're released. No resources. 2 weeks later, they're back on meth. But they've been clean long enough that they want to change, and they need that help then. Indigenous jurisdiction, the people have to have a say. none of this powerlessness, none of this somebody else makes the decision. And then finally, you've got to resource it. So let's do this. Let's take a person who goes to court, serious offense, pleads not guilty, is dealt with Indigenous justice processes and all that. Let's take all the money that would cost to imprison that person and remand, to run the trial, costs of the lawyers, the judges, the clerks, and the cost of the prison stay. Let's take that chunk of money, give it to the community. And where do you get the money? It's hard times. Easy. We'll just take it out of the justice system. Let's do that. And with all of that, miigwech. Thank you for listening.